I'm Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. I want to tell you about a case that came out in May of 2025. It is instructive with respect to the duty of all brokers to advise your clients to seek the advice of an expert in areas that exceed the scope of your expertise. You may remember that in 2012, the Washington State Supreme Court spoke to this issue in a case called Jackowski versus Borchelt. If you don't know that, then you should. And I don't care if you remember the exact case name, but you need to understand how the judiciary has already viewed this agency law duty of all brokers. The duty, again, is to advise your client to seek the advice of an expert in areas that exceed the scope of your expertise. In that Jackowski versus Borchelt case from 2012, the case facts dealt with a house that sat up on a cliff, and the buyer and the seller both knew that there was some instability in the hillside. The transaction closed. After closing, there was a failure in the hillside, and part of the house fell down the hillside. And it was condemned, and the buyer sued everybody, including their own broker. And arguments were made all the way along the judicial system, from the Superior Court to Appellate Court, and then finally got to the Supreme Court. And here, the decision from the Supreme Court is what I'm just going to summarize very quickly for you. At the Supreme Court, the court said that the duty of the broker will extend to a duty to advise the buyer to seek the advice of a geotechnical expert, even if the buyer has some knowledge of their own of the instability in the hillside. So it's not enough for a broker to say, well, buyer knows what I know. I do know there's the potential for instability in this hillside. The buyer knows everything that I know, so therefore there's no reason for me to advise the buyer to talk to a geotech expert. If they wanted to talk to a geotech expert, they could do that themselves. The court said that's not okay, that's not enough, because you have a duty to advise your client to seek the advice of an expert in areas that exceed the scope of your expertise. That is an unwaivable agency law duty applicable to every single real estate broker delivering real estate brokerage services in Washington. Back to the case that came out in May of 2025. The case dealt with the sale of a condominium in downtown Seattle. This was an old building, and there were known roof leaks into the unit that was being sold. This unit and a neighboring unit as well. The buyer had knowledge of these roof leaks. The buyer and the seller both believed, or at least based on the seller's disclosure, the seller believed and led the buyer to believe, and the buyer's broker as well, that the HOA had made a repair to the roof that would have stopped the leaks and potentially prevented future leaks. That was the knowledge of everybody going into the closing. After closing, there's a catastrophic leak into the unit, destroys the interior of the unit. And ultimately, the buyer ends up suing the broker, the buyer broker, among others. And the court held that even though the buyer broker had advised the buyer to have an inspection of the interior unit, the unit itself, the condominium unit, that in a circumstance where there was a known leak, historical known leak through the roof of the building, that the broker should also have advised this condominium unit purchaser to have the roof inspected. Recognize the roof is common area. It wasn't part of the unit. And the court's opinion was that the broker, who had knowledge, just like the buyer, just like the seller, the buyer broker had a duty to advise the buyer to have an inspector go on the common area roof to inspect the roof as well. And a failure to make that advice creates potential liability for the broker. In addition, in this same fact pattern, the buyer broker knew that there was not a current reserve study. In fact, the most recent reserve study for this very old condominium building was about 20 years old. Buyer broker delivered that to the buyer and said, buyer, this is a very old reserve study, but didn't go further to say, and you should get advice from somebody who understands the significance of there not being a current reserve study for this condominium complex. Buyer broker didn't give that additional advice, gave the warning, this is an old reserve study, and the court said the failure of the buyer broker to give that additional piece of advice, and you should get assistance, creates potential liability for that buyer broker. This case takes the Jackowski versus Borchelt line and it takes the agency law provision that we all know. Every broker has a duty to advise their client to seek the advice of an expert in areas that exceed the scope of expertise. And it just applies it to one more fact pattern that stretches, in my opinion, farther than we had thought before within the industry. In a condominium setting, buyers should be advised by their broker to inspect common areas. Might that require the permission of the HOA? Absolutely, it probably will. But if there is a known historical defect in the common area, brokers should be advising clients to inspect that common area. And with respect to resale certificates and reserve studies, if there is some irregularity in those documents, then broker, you should be advising your client to seek the advice of an expert with respect to those issues. It's not enough to hand them the old reserve study or the somehow defective resale certificate and assume that they'll read it for themselves and recognize the problem. You need to go the step further and advise them to seek the advice of an expert with respect to those issues. If you have a question on this topic or any other, please ask me a question by visiting warealtor.org and following the links to the Legal Hotline. Thank you for being a Washington Realtors member.